3 of the accused has already been granted.
In matters of this
No,
kind,
I'm only on.
you cannot seek parity.
No, I'm not seeking parity, my lord. Only for your lordship knowledge, my lord. It's my duty to inform this honourable court that 3 of the accused persons have already been granted bail by the learned trial court itself, and they are regularly appearing before the court.
My lord, though in the charge sheet many witnesses are mentioned, my lord, but it was submitted before this honourable court, my lord. That is, I do not know whether we finished this order. 1-5. Yes, my lord. Lordship kindly turns to page 15 of the petition, my lord. Page 15 is the order passed by this honourable court, my lord, on 1/5/23.
Page 15 of the.
This is the 135.
Yes.
Yes.
No. Page 15.
Of the appeal, my lord.
Yes.
But this was in the earlier bail application, my lord, para 7, if lordship kindly sees, my lord.
Yes.
According to the prosecution, 40 of the possible 70 witnesses have already been examined. The prosecution claims that though more than 150 witnesses are named, it may not be necessary to examine any more than approximately 75 witnesses. The prosecution assesses that the trial as its present pace should be completed in course of this year. The prosecution submits that given the nature of the offence, it is necessary to examine huge number of witnesses. So we have stated before this honourable court, my lord, that approximately 75 witnesses only will be examined. Now 69 have already been examined, my lord. So in my humble submission, it's a matter of now few more days.
Have you indicated that before the trial court?
It has been indicated. It was submitted.
Have you given a specific number that such number of witnesses will be examined apart from the 69 that's already been that were already examined?
That
if you say yes, we confine ourselves to 75 witnesses.
Approximately 75, maybe 75 to 80.
Complete. You have another 4, 5, 6, whatever.
My lord.
Have you done that?
But whether a revised list was submitted or not, that is not with me, my lord.
There was a submission made last year, my lord, saying that the trial would complete by the end of last year.
Now we are almost at the end of this year.
But the very fact, my lord, the 70 witnesses have been examined, my lord.
Yes.
So in my humble submission, it will not indicate that there is a very tardy progress in the trial. It's a quite reasonable pace, considering that there is only one court, my lord. The same court is conducting CBI matters.
Would you like this court to record your submission to say that only 75 witnesses will be examined?
Approximately 75, my lord. That was submitted. Maybe 2, 3 plus minus more depending on how the evidence is coming. And that is what exactly is
it. Will we fail to protect my right to a speedy trial? My lord, in normal circumstances, 6 years is more than enough for completion of the trial. In this case, my lord, I am under custody.
We cannot go back, Mr.
Absolutely, my lord.
6 years is already passed.
Yes, my lord. That is why, my lord, say that.
Now we are trying to ensure that the trial is completed expeditiously.
It is going on right earnest, my lord. It is going on right earnest.
And that would be dependent on the number of witnesses to be examined. Now, if the prosecution has, candidly admitted that only certain numbers of witnesses will be examined, apart from whatever has been or whoever has been examined, then what? My lord,
here most of the witnesses are from Manipur. My lord, the situation in Manipur is volatile, as your lordship is aware. My lord, even if they say that they will examine 75 witnesses, my lord, we will not be in a position to complete it within the next year also. My lord, that submission, my lord, would fail in any case, given the situation we are faced with, for which the appellant, my lord, who is before your lordship, had no role to play. Now, if in certain cases, my lord, if the witness do not turn up, my lord, and that adds on to the delay, my lord, for that the appellant can it be attributed to appellant appellant, and for which can he really be incarcerated for the non-appearance of the witness again?
Well, this is a case under Unlawful Activities Act.
Well, all cases invariably are under UAPA. All cases.
What all cases? I think there are not even 5 cases.
Wherever
in the
the NIA is involved, UAPA is there.
My lord, this is a case under
I'll
UAPA, my lord.
UPA, Explosive Act, whatever.
Absolutely, that is what I'm saying.
Of kidnapping, my lord, collection of ransom, my lord, a ransom for purpose of buying arms, my lord. And underground outfits are involved, my lord, and they are the members of underground outfits, my lord.
Now, all cases where, my lord, UAP is involved pertains to certain underground elements. The lordship in a very recent case, my lord,
examined by this honorable court and Supreme Court also, where even the charges were not framed for a certain number of years. Those are the, here your lordship sees 69 witnesses have been examined.
On the earlier occasion when we moved this honorable court, my lord, there was a specific submission made on their behalf that the trial would end by last year. That did not happen. That prompted us to go to trial court. The trial court again, my lord, basing on the same submission made earlier, my lord, she rejected my bail application. Now tomorrow, my lord, if I again go back to trial court, they will again come up with the same submission, 75 witnesses. But the fact of the matter remains, another year will pass by then. The only thing is, my lord, here the prosecution has miserably failed to protect my right to speedy trial. As your lordship is aware, my lord, when a prosecution fails to protect my right to speedy trial, which is intrinsic to Article 21, they don't even have a right to oppose my bail application. That is what the Supreme Honorable Apex Court has held.
Let them place some judgments, my lord. Let them place judgment where 69 witnesses have been examined.
Yes, there are matters, my lord, where the Honorable Court, even in cases where the witnesses have been pruned, my lord, have, considering the fact that the accused person have, my lord, spent about 2 to 3 years in jail, have granted bail. The Honorable Apex, I'll place those judgment. It is with me.
Please give me a copy also.
I'll take few. I'll take your lordship to one judgment, my lord, 2021 volume 3, SCC 713. This is in this, my lord, this judgment, your lordship, the Honorable Apex Court had the Honorable Apex Court, my lord, rejecting the contention of the prosecution, my lord, that the matters are serious in nature, my lord, have held in paragraph 17, 18 and 19, my lord.
Yes.
If I may read, my lord. It is thus clear to us that the presence of statutory restriction like section 43D5 of the UAPA per se do not allow the ability of the constitutional court to grant bail on grounds of violation of part 3 of the constitution. Indeed, both the restriction under a statute as well as the power exercisable under constitutional jurisdiction can be well harmonized. Whereas at commencement of proceeding, the court are expected to appreciate the legislative policy against grant of bail, but the rigors of such provision will melt down when there is no likelihood of trial being completed within a reasonable time, and the presence of incarceration already undergone has exceeded a substantial part of the prescribed sentence. Such an approach would safeguard against the possibility of provision like section 43D5 of the UAPA being used as a sole metric for denial of bail or for wholesale breach of constitutional right to speedy trial. Adverting to the case at hand, we are conscious of the fact that the charges leveled against the respondents are grave and serious threat to societal harmony. Had it been a case at the threshold, we would have outrightly turned down the respondent's prayer. However, keeping in mind the length of the period spent by him in custody and the unlikelihood of the trial being completed anytime soon, the High Court appears to have left with no other option to grant bail. An attempt has been made to strike a balance between the appellant's right to lead evidence of his choice and establish the charges beyond any doubt, and simultaneously the respondent's right guaranteed under Part 3 of our Constitution have well been protected. Yet another reason which persuades us to enlarge the respondent on bail is that Section 43d5 of the UAPA is comparatively less stringent than Section 37 of the NDPS Act. Unlike the NDPS Act, where the competent court needs to satisfy that prima facie the accused is not guilty and that he is unlikely to commit another offence while on bail, there is no such precondition under UAPA. Instead, Section 43d5 of the UAPA merely provides another possible ground for the competent court to refuse bail, in addition to the well-settled consideration like gravity of the offence, possibility of tampering with evidence, influencing the witnesses, or chance of the accused evading the trial by absconding, etc. All right, here, Lordship, considering the fact that the appellant has undergone substantial period of custody already, and to strike a balance between the prosecution choice of evidence as well as the right to speedy trial of the accused person, the Honorable Court has granted bail to them, to the accused person. Now, the other aspect, no, it is with you. Just check. I'll place another. I'll place another judgment. This is a very recent one, 2024. The relevant paragraphs you also will find at para 8, 9, para 18, 19, 20, 21. And in this case, the reference to the judgment of K. Najib, which I just placed before Lordship, has also been taken. Para 8, if I may read. Having regard to the aforesaid, we wonder by what period of time the trial will ultimately conclude. However serious a crime may be, an accused has a right to speedy trial as enshrined under the Constitution of India. Para 9. Over a period of time, the trial court and the High Courts have forgotten a very well settled principle of law that bail is not to be withheld as a punishment. Now I'll take your Lordship to paragraph 18. Criminals are not born out but made. The human potential in everyone is good, and so never write off any criminal as beyond redemption. This humanist fundamental is often missed when dealing with delinquent juveniles and adults. Indeed, every saint has a past and every sinner a future. When a crime is committed, a variety of factors are responsible for making the offender commit the crime. Those factors may be social, economic, may be the result of value erosion or parental neglect. Maybe because of the stress of circumstances or the manifestation of temptation in a milieu of affluence contrasted with indigence or other provision. If a state, my lord, or any prosecuting agency, including the court, consent has no wherewithal to provide or protect the fundamental right of an accused to have a speedy trial as enshrined under Article 21 of the Constitution, then the state or any other prosecuting agency should not oppose the plea for bail on the ground that the crime committed is serious. Article 21 of the Constitution applies irrespective of the nature of the crime. We may hasten to add that the petitioner is still an accused, not a convict. The overarching postulate of criminal jurisprudence that an accused is presumed to be innocent until proven guilty cannot be brushed aside lightly, however stringent the penal law may be. We are convinced that the manner in which the prosecuting agency as well as the court have proceeded, the right of the accused to have a speedy trial could be said to have been infringed, thereby violating Article 21 of the Constitution. Now, having said that, my lord, the Honorable Apex Court goes on to grant bail to this accused person. My lord, the other judgment is of Again, this is again very recent, 2021. It was authored by Honorable Justice Ujjwal Bhuiya, my lord. I'll refer to relevant paragraph would be paragraph 21, 22, my lord, 23 and 20.
21
21, 22, 23 and 20, my lord.
and 20 and 24.
20, my lord. 20.
You're going from 21.
Oh, sorry, 23. Sorry, 23 and 23.1. And 27.1 and 28, my lord.
27.1.
27.1. Lord, 28. Of course, in some of the paragraphs, what was laid down in the K.A. Najib's matter has been reiterated again. Reiterated. I'll take your lordship to paragraph 21. Para 21. It is true that the appellant is facing charges under Section 489B IPC and under Section 16 of the UAP Act, which carries a maximum sentence of life imprisonment if convicted. On the other hand, the maximum sentence under Section 489 IPC is 7 years, but as noticed above, the trial is proceeding at a snail pace. As per the impugn order, only 2 witnesses have been examined, thus it is evident that the trial would not be concluded in the near future. Now, it is a trite law that an accused is entitled to a speedy trial. This court in a katana of judgment has held that an accused or an under trial has a fundamental right to a speedy trial, which is traceable to Article 21 of the Constitution of India. If the alleged offence is a serious one, it is all the more necessary for the prosecution to ensure that the trial is concluded expeditiously. When a trial gets prolonged, it is not open to the prosecution to oppose bail of the accused under trial on the ground that the charges are very serious. Bail cannot be denied only on the ground that the charges are very serious, though there is no end in the sight for the trial to conclude. Now again, my lord, the judgment which I just placed, your lordship, that has been referred here in paragraph 23. Now I'll take you to paragraph 23.1. After referring to various other decisions, this court further observed as follows. If a state or any prosecuting agency, including the court concerned, has no wherewithal to provide or protect the fundamental right of an accused to have a speedy trial as enshrined under Article 21 of the Constitution, then the state or any other prosecuting agency should not oppose the plea for bail on the ground that this is again the reiteration of the earlier judgment, my lord. I'll take your lordship then straight to. But again, my lord, here basically they have relied on the earlier 2 judgments which I have already placed. Now, again, my lord, one more judgment. Sorry, I only have one copy. But my lord, I have marked the relevant paragraphs. My lord, may I go through? Paragraph 7. Oh.
You don't have the journal for this?
Well, it was taken out from the official website of the, if you'll achieve, of the Supreme Court, my lord, official website.
By now you would have got the SSC online.
We can have it, my lord. There is no problem. My lord, may I kindly go through this, my lord. I will place it in the today itself. A very short judgment, but
Yes, anything else?
Beg your pardon, my lord.
Anything else?
Yes, my lord, here the other aspect is, my lord, they are saying that the trial is going right earnest and it would be complete within a period of so and so date. My lord, your lordship is aware that, my lord, making a submission that the trial would expedite by the end of next year, again, my lord, would not be tenable in view of the judgment that High Court Bar Association Allahabad versus State of UP's matter, my lord, where the Honorable Apex Court has said, my lord, when it comes to the trial, a fixed timeline cannot be fixed. So even if they say, my lord, that they would be able to complete the trial possibly within the next year, that again falls flat or fails, my lord, in view of the judgment rendered in that
Mr.
particular
Thapa, you're
case.
wrong. See, when the court says that the timeline cannot be fixed, means the timeline cannot be fixed by the court.
Absolutely.
But if it is on the admission of the parties concerned, particularly the prosecution,
My lord, again, that cannot be the ground for denial of bail merely because of the fact that, my lord, here
that is beside
substantial period of time has already
that is
been.
beside the point.
Absolutely.
We are talking about the
I bow
timeline
down.
here.
I would bow down.
Anyway,
I humbly pray, my lord, in the earlier matter, my lordship very recently had been, of course, that case has now connection with me in my case, my lord. But what I'm basically trying to implore upon this honorable court is that, my lord, in a similar case where the accused was, my lord, charged under UAP and Explosive Act, your lordship, considering the fact that he has undergone 2 years of punishment, and besides he's in parity with the other accused person who has already been enlarged on bail, your lordship was pleased to grant bail to the appellant concerned. My lord, with the condition, my lord, that he shall appear before the police station concerned on every weekend, so on and so forth, my lord. He may also be, my lord, humble appellant, my lord, before your lordship may also be granted bail with any strict condition that your lordship may impose upon me. That shall be strictly complied, my lord.
we've heard the parties, we'll pass this order.
But I'll only place one judgment.
Yes.
My lord, the citation is 2024. 2024, Volume 5, SCC.
2024,
Volume 5,
SCC online,
SCC, my lord.
Oh.
403.
volume,
Volume 5,
SCC,
403. Page number 403.
para,
My lord, the citation is Guruvinder Singh versus State of Punjab, my lord.
para.
Para, my lord, 45 and 46. I'll just read these two paragraphs, my lord.
Yes. Please.
In K. Najib's case, this court was confronted with a circumstance wherein, except the respondent accused, other co-accused had already undergone trial and were sentenced to imprisonment of not exceeding 8 years. Therefore, this court's desire to consider bail was grounded in the anticipation of the impending sentence that the respondent accused might face upon conviction. And since the respondent accused had already served portion of the maximum imprisonment, that is more than 5 years, this court took it as a factor influencing its assessment to grant bail. That the Najib's case is distinguished, my lord. Further, in K. Najib's case, the trial of the respondent accused was severed from the other co-accused owing to his absconding, and he was traced back in 2015 and was being separately tried, and thereafter, and the NIA filed a long list of witnesses that were left to be examined with reference to the said accused. Therefore, this court was of the view of unlikelihood of completion of trial in near future. However, in the present case, the trial is already underway and 22 witnesses, including the protected witnesses, have been examined. So the case that is dealing, the Supreme Court is dealing, my lord, 22 witnesses examined. Then it says, my lord, as already discussed above, the material available on record indicates the involvement of the appellant in furtherance of terrorist activities backed by members of banned terrorist organization involving exchange of large quantum money through different channels, which needs to be deciphered. And therefore, in such a scenario, if the appellant is released on bail, there is every likelihood that he'll influence the key witness of the case, which might hamper the process of justice. Therefore, mere delay in trial pertaining to grave offences as one involved in the instant case cannot be used as a ground for grant of bail. Hence, the aforesaid argument on behalf of the appellant cannot be accepted. But even where 22 witnesses were examined, the learned Supreme Court, the Honorable Supreme Court rejected the bail, my lord, in this case. Here is a case we have examined 69 witnesses, and this is also a case of terrorist activities, my lord. unlawful activities. There's a case of kidnapping of a company of a manager of a company, my lord, who was doing some road construction in railway construction work in Manipur, my lord. And the money was ransom was demanded. Ransom in fact, a part of ransom was collected, and that was it is clearly shows, my lord, that with that money they were buy arms and other things. My lord, the second aspect, because the accused person is from Manipur, my lord, the flight risk, my lord, he disappearing in some other neighboring country is very high, my lord. So these are the factors, my lord. Lordship kindly consider. I've given the list of books, my lord, but the Lordship will kindly examine this judgment.
And the other
This
thing,
is 2024
Lordship,
judgment.
this Gurvinder Singh judgment, my lord, is again been referred in the judgment which I have already placed. My lord, here in a of course, my lord, in a soma sense matter, my lord, where the Honorable Apex Court has clearly made a distinction as and have further gone on to say that Gurvinder Singh will not hold field insofar as the bail application when a person concerned has already undergone substantial period of custody without a trial being complete. This distinction has already been made. And my lord, this particular Gurvinder Singh judgment has been referred in that para 31, my lord, of Sheikh Javed Iqbal's judgment, my lord. 2024 SCC Online SC 1755. You'll also may kindly have para 31. What weighed before the court to my lord, consider the judgment passed in K. Najib's and negate the ratio laid down in Gurvinder Singh, my lord, in para 31 of Sheikh Javed Iqbal's case, my lord, 2024 SCC Online 1755.
Yes.
Para 31, my lord. In Gurvinder Singh, my lord, they had not undergone substantial period of incarceration.
Yes.
And making a distinction between Gurvinder Singh and K. Najib's, my lord, the Honorable Apex Court was pleased to grant bail. And my lord, in this case, all the witnesses, all the accused persons are from Manipur. Nobody are from Shillong. 3 accused already granted bail, my lord, they are already facing trial in right earnest.
But one of the cases, though, didn't furnish me copy. Only 2 witnesses were examined. Lordship noticed that, and that was the reason the court has granted bail.
That of course. We've heard the parties will pass this.
Item number 5.
problem is, they engaged 3 to 4 lawyers. They came for us in the appeal.
Please, Your Lord. My Lord, I beg to mention item 4 and 5, my Lord. I humbly pray the matter come up after 2 weeks, my Lord. The conducting counsel, Mr. Philemon Numbri, is having personal difficulty today, my Lord.
To transport matter
No, Your Lordship, those
Salary
are
matter, my Lord.
suspension.
or suspension.
Yes, Lordship.
On primary petitioner, this is matter to 3 weeks.
Oblige, Your Lordship.
Deeply obliged, my Lord.
With this Lordship. Lordship, I beg to mention item number 10, Lordship.
Yes.
Lordship, here I was supposed to file the compilation, my Lord. There has been some technicalities, my Lord. It's taking time. Can you grant me two more weeks, my Lord, to file the compilation, my Lord?
10. What about 9?
9, my Lord. Actually, hearing was done on 10. So 9, 10, my Lord. If 10 is taken up, 9 also will be covered. 9 also can be, my Lord, have on the same date, my Lord.
Primary
I have filed my written submission, my Lord.
You have
I have
filed?
argued the matter, I have filed my written submission.
He has not even started his argument. Have you started?
We had started, my Lord. So subsequently, my Lord, some issue came up. So we, my Lord, we are supposed to file the.
No, so initially they said that they'll be covered by senior counsel.
Yes, but we will cover, my Lord. But there are some points, my Lord, we have to advance in addition to what has been argued by, my Lord, the counsel for the impeachment, my Lord.
No, we are talking about 9 and 10.
Yes, my Lord.
You're not in 9 and 10.
I'm in 9.
You're in 9.
9 basically, my Lord, we had challenged the order by which the trial was segregated, my Lord.
Yes, yes.
So, my Lord, if this
That
matter is decided,
that is directed particularly against the A3.
Lordship, Lordship.
My Lord, but the main matter, my Lord, because in my humble submission, these other matters will be dependent on them.
Yes, my
If if the matter that has been argued by senior counsel, Mr. Khurshid, if that is decided in their favor, it will become redundant, my Lord.
Okay.
But if it is decided in favor of CBI, my Lord, then this will survive.
But there, I think if you overall, if you take all these matters into consideration,
my Lord,
there are two aspects. One is with regard to the framing of charge,
there's asking for quashing the charges itself, my Lord.
yes, to quash the charges. That was the prayer.
My Lord,
So that's one part.
my Lord,
The other part is as far as the role of the A3 is concerned.
my Lord.
Yes, but that would follow. If charges are quashed, then
Automatically goes, my Lord.
everything goes, my Lord.
Order matter become infructuous, my Lord.
But
not
this would cooperate also to complete the argument, my Lord. This is like I also tend to forget, my Lord, what I argued on the last moment.
But now I have forgotten that you have started. You have already.
I'm tendering my apology, my Lord.
On premier by the petitioner, this is matter up to 3 weeks. What about 6, 7, and 8? You are not.
7 is the main matter, my Lord.
7 actually. Not filed, I think. Not filed.
7 is the main matter, my Lord.
Yes.
But
You are
this
not
matter
in this case.
also can
You are not
matter.
in 7.
I'm only on 6, 8, and 9.
Yes, Dr. Muzika. What about 7?
The 7 is the matter with Mr. Khurshid argued the matter.
Yes.
I have already filed my synopsis of arguments.
Oh, they are
I think
supposed to file.
petitioner yet to file, my Lord.
File the rejoinder.
Not rejoinder, in fact, the written argument.
Correct now. They have
Yes,
not-
my Lord. No, not filed, my Lord. As far as my understanding, my Lord.
This matter is going nowhere.
So we'll let the matter be called off. No?
My Lord.
They
They
may
have called
appear.
out, my Lord.
This may also, my Lord, come together, my Lord. Together after 3 weeks, my Lord.
No, the matter will be called out.
You, as far as your matter is concerned, fine.
Yes, madam.
3 weeks.
Because she
Now we're
doesn't
talking
seem to
about
be.
6,
Yes.
7, and 8.
My Lord.
That since nobody is there on behalf of the petitioner, you have to wait for them.
But only judge.
From daily list, item number 1.
Amit, His Lordship.
Yes.
Lordship, in this matter, we need some more time, Your Lordship. Some more time. 10 days time will.
So you're saying that the order of the Supreme Court did not deal with this matter specifically or with the issue?
Lordship, there is an order of the Supreme Court that the High Court may decide the matter, individual matter, in accordance with Lordship.
This is only with regard to the decision of the government on the application for
Lordship,
Yes,
yes.
Lordship.
Lordship, yes.
pre-made by Mr. Anishwar AG seeking accommodation. That is adjourned. This is here after 3 weeks.
Okay.
Not objected to by petitioner.
Item number 2.
May it please your Lordship. Lordship, my humble submission is that, my Lord, I have just received the SSC citation just this morning, my Lord. So my only humble prayer before your Lordship is to kindly grant me some, at least 1 week time, my Lord. I may be allowed to go through the judgment which my learned senior has given me, my Lord, this morning, my Lord, so that I can make proper submissions on the next day.
To help you or to against you?
My Lord, that I have to read, my Lord. I have just,
Law is well settled.
my Lord, I have just
Only one
received.
paragraph. I don't think there is any counter to that, my lord. Into Constitution bench of the Supreme Court in Sanjay Dutt's case, my lord, has clearly held that if there is an extension application for investigation and if there is a bail application, both should be considered together. And if extension is granted, bail has to be rejected. Well, there is no
We'll
escape.
have to look at the facts of this case.
Yes, my Lord.
At the relevant point of time, whether I think that was the issue we were.
Our extension application was filed prior in time, my lord. But the Supreme Court says that it's not necessary to file prior in time also. It says, my lord, when a bail application.
Even after the stipulated period, so you can still file for
Still
extension.
file it, my lord.
What would be the issue of
I'll just point out
default bill?
only one paragraph, my lord. No, you can take time, there's no problem.
I'll
But
give
I'll
you
just
time.
point out.
You can respond.
94, volume 5.
You get as many decisions as you want.
Para 48. The Sanjay Dutt's famous case, my lord. It's a constitution-based decision, my lord. At page 442.
Yes.
I'll just read one paragraph, my lord. We have no doubt that the common stands before us of the nature of indefeasible right of the accused to be released on bail by virtue of section so-and-so is based on a correct reading of the principle indicated in that decision. The indefeasible right accruing to the accused in such a situation is enforceable only prior to the filing of the challan, and it does not survive or remain enforceable on the challan being filed, if already not availed of. Once the challan has been filed, the question of grant of bail has to be considered and decided only with reference to the merits of the case under the provisions relating to grant of bail to an accused after filing of the challan. The custody of the accused after the challans has been filed is not governed by section 167 but different provisions of the Code of Criminal Procedure. If that right had accrued to the accused but it remained unenforced till the filing of the challan, then there is no question of its enforcement thereafter, since it is extinguished the moment challan is filed, because section 167 CRPC ceases to apply. The division bench also indicated that if there be such an application of the accused for release on bail and also a prayer for extension, this is the important sentence, my lord. The division bench also indicated that if there be such an application of the accused for release on bail and also a prayer for extension of time to complete the investigation according to the provision of section so-and-so, both of them should be considered together. It is obvious that no bail can be given even in such a case unless the prayer for extension of period is rejected. In short, the grant of bail in such situation is also subject to refusal of the prayer for extension of time if such a prayer is made. If the accused applies for bail under this provision on expiry of period of 180 days or the extended period as the case may be, then he has to be released on bail forthwith. The accused so released on bail may be arrested and committed to custody according to provisions of the. It is settled by Constitution Bench decision that a petitioner seeking the writ of habeas corpus, that is not, well, that particular sentence, my lord, where it says that extension application and bail application have to be considered together. And in fact, they have referred to Hitendra Vishnu Thakur in this para, my lord. I'll place that decision also. I've given the citation of both to my friend. So what basically Supreme Court says, my lord, after, for example, 90 days, my lord, if the challan is not filed, that period after 90 days, default bail is the right accrues. But supposing that on 95th day bail the challan is filed, charge sheet is filed, and they come after 95th day for a default bail, that's not permissible. They have to come before 95th day, number one, and number two, only in some laws, special laws, my lord, like NDPS Act and unlawful activities, there is a provision for extension of time of investigation also. This is not there in CRPC. So in case of a special laws where there is a provision for extension of time for investigation, if such an application has been filed, both have to be taken up together.
The court will examine that as well. On made by Ms. Snoxy, learner counsel for the petitioner, seeking accommodation. Matter is adjourned. List the same after puja petition.
Highly obliged, my lord.
Item number 3.
Six is the petition you have filed.
The first one.
So 6 and 9 same. Or,
No, my lord. 6 and 9 are same, my lord. Same. 6 and 9 are same.
because it,
7 and 10
it
same.
involves A3.
Correct, my lord. Correct. For 7, I've taken the instructions, my lord. The matter, they are praying, my lord. The matter also can come up after 3 weeks, my lord. Item number 7, my lord.
Yes. You filed your written argument here.
I filed my-
Item number 7.
What I pray, my lord, there are 3 types of matters in this batch. If the quashing petition, the quashing of charges, that is disposed of first, my lord. The senior counsel has argued, I have also argued. I have also filed my written submission. They also, I think,
They're
filed.
waiting, that's what he said. They are asking for time to file.
My-
Mr. Yes. Until learned counsel for the has submitted that on being instructed. You're not in this case.
I'm there, my lord.
Are you there?
Yes, my lord.
As learned counsel for the petitioner has submitted that that the written argument could not be filed today and has sought for time for the same to be filed. Sought for some more time for the same to be filed. Payment is same as the law. This is matter of the 3 weeks.
Oblige, Judge.
Kita wish to obey. This is matter of the 3 weeks.
Yes, 27.